you for joining us on our first commercial and dispute resolution Q&A. As you can see at the bottom of the screen, there is a Q&A function. So if you do want to ask any questions as we're going through the session, then please do click on that link and type your question in there. Please don't use the chat function as it may get missed. And as and when we come to your question, we will read it out. We've received a number of questions as well before the session, so we'll run through those as well. So to introduce myself, for those of you that aren't aware, my name's John Pickervance and I'm a partner and head of the commercial team. We're also joined by Stephen McArdle, who is a partner and a member of the commercial dispute resolution team. So Stephen and I regularly work together on contracts and contractual disputes, and there's been quite a bit of crossover in our areas regarding COVID-19 and some of the questions that were being asked. So without further ado, I'll pass over to Stephen to run through a few of the questions that he's got.
Yeah, thanks, John. So as John's explained, contracts and COVID-19 is a hot topic at the moment, and a lot of our clients have been asking questions about the effect of COVID-19 on their contracts, either whether they're suppliers or parties in receipt of goods or services, and from many different sectors and industries as well. We found that whether, the relationship you've got with a customer or supplier, or delivery or logistics, goods and services, everything seems to have been affected, and to some extent remains being affected by COVID-19. And probably the most common question which I've been asked to advise on recently, and I'm sure John is the same, is what happens to contractual obligations in the present context? And one of the things I advise clients is that once you have a contract, it's properly put together and the parties know what they're doing, those obligations under the contract must be performed. And so you have to turn to the contract in the first instance to see whether or not there is anything within the contract which permits a party to alter their performance obligations and marry it to the present circumstances. And we've had a couple of questions already on force majeure. So I was just going to start, if that's okay, with covering what force majeure is and taking you through some of the issues that you might want to consider at the moment. So basically, it's an emergency contractual provision. It will be within your contract, and it alters the usual obligations under the contract, and often acts as a limit on liability if certain extraordinary circumstances apply. The applicability of a force majeure clause and how a non-performing party will benefit from one really will depend on how it's drafted. And it is a common misconception that just because there is a force majeure clause in your contract that it will excuse a party from not performing its obligations. But typically the starting point is to locate the clause, and you'll see that these commonly will either allow a non-performing party to do something different. It may protect that non-performing party from a breach of contract claim, may provide an extension of time to perform certain obligations, and in some circumstances it also allows the contract to be cancelled. It's important to note that whether or not you are faced with a situation where somebody else is trying to rely on a force majeure, or you're trying to rely on a force majeure clause, the burden of proving that it applies rests on the party trying to rely on it. So given how important that clause is to a contracting party, and the protection that it might afford you or somebody else who you might be in dispute with, it's important that you take a number of steps, I would say, before you launch into a debate about it. So first things at first, carefully consider the clause itself. Has a force majeure event occurred? Of course, a lot of these clauses will cite things like pandemics or epidemics, and I think it's not in doubt that COVID-19 will comply with that. It might also refer to government acts or orders. So these might relate to the circumstances surrounding the lockdown and how that's affected business and obligations under contracts as well. They may even refer to events outside a party's control. So again, looking at the COVID-19 situation, it's likely that that is going to apply to that type of clause. The second thing I would suggest you do is look at demonstrating that the force majeure event has in fact affected the performance of the contract. So again, this is what we call causation, and it's key really to get evidence together to prove that the circumstances that business is facing has directly affected that particular obligation which might have been affected. And so typically you'll be looking at things like, has the obligation been prevented from being, party being prevented from being carrying out their obligations under the contract, either legally or physically, whether they've just been hindered by the COVID-19 lockdown, or merely just delayed in performing their obligations. So they're different levels which the clause might have drafted within it. And you'll also have to show that you've attempted to comply with your obligations, even if it's been difficult to do so, and that you've been mitigating the effects of the force majeure event as well before you actually rely on that provision. The final thing to have a look at within your contract when you're identifying a force majeure is any notice requirements. So it's common for contracts to have very specific notice provisions, which mean that a party who wants to rely on it will have to serve notice on the other party in a prescribed way, in terms of how the contract says that has to be done. And that's a precondition of actually relying on a force majeure clause. So that's basically a bit of an overview of what force majeure is, the sorts of things you might want to look at. John, I don't know if you want to add anything to that.
Nothing to add on the topic of force majeure, but I think it comes into question when we're looking at the obligations for performing the contract. I've been asked a very specific question. If you can't get out of performing your obligations by virtue of a force majeure clause, whether there isn't a force majeure clause there or it's insufficiently drafted, then how might I be affected under the contract? Well, what we need to look at now is the extent to which a performance obligation is, first of all, absolute. So if it states in there that party A shall, and then it will go on to describe the obligation, then there is no way out of that, no matter how unfair or unreasonable or uncommercial the performance of that obligation may be. If you don't have the ability to get out of it on the basis of a force majeure clause, then you will have to perform that obligation. Short of an absolute obligation, we often see clauses that state that a party has to use a certain level of endeavours to comply with that obligation. So just shy of an absolute obligation is the requirement to use your best endeavours. Now that means that you must do absolutely everything available to you as a party to perform that obligation, no matter how much it may cost or take away from you in terms of time resources to perform. It may even result in the contract becoming unprofitable just to perform that obligation, but you must do what you can. Slightly more middle grounded is the duty to use all reasonable endeavours or reasonable endeavours under the contract. And what is reasonable in any given situation will really depend on the circumstances. So in those cases, would it actually mean expending a lot of money or the contract then becoming unprofitable in order to perform that obligation? If that is the case, then it's a good case to have in terms of pointing to something being unreasonable to perform. So first things first, check your force majeure clause and then check to what extent you're required to perform that obligation. Finally, on performance, you also need to have a look at warranties. So it may be that you can still perform the obligation itself, but you might be warranting or making a contractual promise that you will do it in a certain way. So you will do it within a specific time frame or to a specific standard, for example. That may now be impossible due to COVID, in which case you need to make sure that you're not going to trip up on any of those contractual warranties. And we'll come on to liability and indemnity in due course as well. Okay, Stephen, so I'll hand back to you.
Yeah, I've just had a question before we started about what would the position be if there's no force majeure clause in the contract. So that's quite a good question. So if you have a commercial contract and the obligations under that contract are being affected by COVID or the lockdown, not having a force majeure clause in there doesn't mean that it's an automatic breach. There is a potential to rely on what's called a doctrine of frustration. This is where effectively the parties are completely discharged from their contractual obligations entirely if there's a change in circumstances or contractual circumstances which were unexpected and beyond the control of the parties and makes performance physically and commercially impossible, or would render the performance radically different to what was intended by the parties. The doctrine of frustration is a common law provision. It doesn't have to be in your contract. It is quite a dramatic provision, and actually in practice, the reliance on that, or where parties seek to argue a contract's been frustrated, is quite rare. The legal tests and the legal bar in terms of proving it is quite high, and because it results in the contract being set aside automatically, unlike what happens in a force majeure clause, for example, means that courts are not that quick to make a ruling that a contract's been frustrated. It is always worth looking at frustration, taking advice on that, depending on your circumstances, because it might suit the particular situation you're in. For example, I was trying to think of an example of frustrating events, and something like if a new law was brought in banning public gatherings, and that then impacted on the contracts. For example, if a music event was staged, a concert or something like that. So obviously the actual concert itself couldn't take place as a matter of law due to the COVID-19 situation. That is likely to be a frustrating situation, and it might render the contract at an end. But as I say, that isn't always commercially what the parties want. It is always worth considering it. It might be a negotiation point potentially. But as I say, it's a fairly high bar to rely on.
Okay, so to move on to the next question that I received, what are the consequences of non-performance? So if you're completely prevented from performing your obligation under the contract, what is going to be the likely outcome, practically speaking? So this will really depend again on the wording of the contract. First of all, you need to check if that force majeure clause is there. If it is there, then what a force majeure clause tends to say is that if that event continues for a specified period of time, and generally it's somewhere between 2 or 3 months, then that will enable the unaffected party to terminate that contract. And if that's the case, then it's likely that the contract will fall away and the party who's been affected from performing their obligations will be able to remove itself from the contract without consequence, which is great. If, however, you don't have the force majeure clause, or it doesn't go far enough, or it doesn't deal with termination, then you will need to assess to what extent the contract has been breached. If it's just the case that contract is in abeyance and the performance is just at some point in the future, the parties have decided that it will be put on hold, then the parties are obviously open to bring it to an end as a compromise. If, however, one party wants to take a hardline stance, then they will look at the termination clause and whether there's actually been a breach. So don't merely assume, as the party that's been affected by the other, who has been unable to perform their obligations, that you can simply terminate the contract on immediate notice due to breach. That is only the case in very, very extreme repudiatory breach situations. In most cases, you will require the other party to remedy the breach, and they may be given a specified period in which to remedy that breach. Say 14 days or 30 days are the most common timeframes. If they still can't perform their obligations within that period due to force majeure, then in that case, the contract will be brought to an end. You then need to look at the consequences of termination clauses to see what the outcome is going to be. So will you be able to recover liquidated damages, for example, if there's been non-performance? So that may be a set payment which is paid to the affected party based on a delay or a non-performance. It may be monetary in terms of time delayed or warranties breached, for example. So really do knuckle down into the terms of the contract. Failing that, have a look at the liability and indemnity clauses. If you, the party who's prevented from performing your obligations, is required to give an indemnity, then that's a very significant level of remedy which is available for the other party. It means that they can essentially make a demand to you for losses that they have suffered as a result of your non-performance, and don't have to prove that that non-performance has necessarily caused that loss. So it's a very, very serious remedy clause, and do try and avoid indemnities if you are a provider at this stage in particular. Failing there being an indemnity, and generally speaking, just to look at your overall exposure or the exposure of the other party who may be performing the obligations or prevented from performing the obligations, have a look at the limitation of liability clause. Now, this will tend to be split into two parts. The first is what we call the exclusion of liability, with the second being the limitation. So to look at exclusions, first of all, this may completely exclude certain types of loss that the other party may suffer due to non-performance. So it may be that you're unable to claim for loss of profit, for example, loss of contract, damage to goodwill and reputation. So these are all common things which are excluded from a contract. So do make sure that you check that exclusion clause so that you're fully aware of what you can claim or what your exposure may be. And second of all, for all those things that aren't excluded, what is my financial exposure? So what's the limit on my liability for those direct losses that I haven't excluded? Now, commonly you will see something which aligns with the value of the contract. So your maximum exposure may simply be to give someone a refund or to make a payment of an equivalent sum. But often, and dependent on the bargaining power of the parties at the very outset, it might be that you're even providing a limit of somewhere up to your insurance cover. But be very, very careful in that situation, because your insurance may not actually cover you at the moment for a failure to perform arising out of COVID. And that's something we're seeing quite a lot, and it's a very commonly asked question. So make sure that you specifically negotiate the exclusion and liability, limitation of liability clauses, not just now in light of COVID, but in any case, because you don't really know in future what's going to happen, which may prevent or hinder your performance of the contract. So it's very, very important to look at those. Okay. Stephen, have you got any other questions that you've been asked?
Yeah, I think that's a good point you've just made there, John. It's probably worth everyone just reflecting that aside from what the contract might say about damages, the purpose of an award in damages, so when a matter goes before a court, the purpose of a claim in damages is to compensate the party who suffered from the breach and who suffered loss, rather than punishing the party that's caused the breach. And that's quite an important thing to remember when deciding how to approach a potential breach in terms of how serious the breach is, and what tactics to deploy when you're in that situation. So the general rule will be that damages should, so far as a monetary award, I suppose, could allow it, be foreseeable and put the claimant in the position that they were had the contract been performed. So that's the core contractual damages test, really. And as John said, the majority of contractual damages awards compensate for financial loss, but again, it depends on what the contract says. But that's likely to include things like costs incurred, losses suffered, even liability that the claimant might have incurred to a third party, but it wouldn't have incurred but for the breach. and also profits that the claimants missed out on. So, yeah, I had another question here, and it sort of focuses on negotiation. And the question was, in the context of a contract that's been disrupted due to coronavirus, is it a good idea to negotiate with the other side now, or wait until a breach has arisen, which would tactically be the best approach? That's a good question. And I suppose the premise of that question is that a breach is likely to occur, or maybe a minor breach has occurred, but more along the way, more foreseeable. Well, I think obviously the first thing to do is check your contract and look across the force majeure provisions that you have in there, and also the other provisions which John has just covered. But if the disruption is anticipated, and I suppose if there's a good relationship between the two parties, then there's potentially no harm, I suppose, in holding without prejudice discussions to look at perhaps which obligations in the contract might be altered to take into account the effects of the pandemic. Many businesses will, want to prioritise the preservation of the commercial relationship and future business as the lockdown is eased. And so it's right to focus on maintaining that relationship and possibly negotiating any disputes. I would say it's important to get proper advice if you're entering into those negotiations, because a variation at this stage might not be right for the future. It's important to obviously have any points of negotiation variance noted properly and drafted by a lawyer, ideally. But it is, in principle, I suppose, right to consider negotiating with the other contracting party to see if there's a mutually agreeable solution that you can reach. In my experience, from a litigator's point of view, one of the key tools that we have is a point of negotiation is mediation. It's a particularly effective form of dispute resolution, and it's something that really comes into play if you are in a dispute, so you've moved on beyond the breach of contract and you can't resolve your differences. And it also really helps if the parties are in a particularly contentious relationship, so they can't communicate particularly well. There's a lack of trust perhaps between the businesses. But mediation is a form of assisted settlement where the parties jointly instruct a mediator who's neutral, and that independent mediator will help to broker a compromise and a settlement. The mediator doesn't decide the outcome of the negotiation, but they do facilitate a discussion which might otherwise be difficult. Usually they take place in person at a neutral location, but at the moment they have been quickly adapted, and they now happen virtually, either by Zoom or other online video conferencing platforms. If you are in a dispute and you are considering mediation, or in fact if your contract stipulates that mediation should be embarked upon, then I would advise you do have legal representation to make sure that the best result is achieved.
Okay. A further question that I was asked is in relation to the delivery or provision of goods. Obviously, a lot of businesses at the moment are suffering from cash flow issues, and particularly in a few months' time when we start to come out of this, there's a projected recession, and particularly when the furlough payments stop, cash flow issues may actually get worse. So if I'm delivering goods to someone, how can I make sure that I'm protected if I'm not paid for those goods or the customer goes insolvent at some point in the future? The best thing you can do, short of obviously obtaining payment up front, is to make sure that you have retention of title clauses in your contract. Now, retention of title clauses are great because the assumption at law is that the ownership of those goods will pass to the customer on delivery if you don't have something built into your contract. Now, this will mean, if it's drafted properly, that you will retain ownership until you've obtained full payment for the goods, and that you can then take certain steps in the event of, first of all, non-payment. So it may be that you've got 30-day terms and you've gone beyond those. So we now want to seek recovery of those goods, or alternatively, you might still be within the payment period. So non-payment hasn't been breached yet or hasn't occurred yet, but the contract party, the customer, may go insolvent. So again, that may be the trigger event that enables you to want to start to recover those goods. What you need to do is make sure that your contract goes far enough to say that you can physically enter the premises of the customer to recover those goods. Because even with a well-drafted retention of title clause, if you don't have the right to go into that premises, you can't physically get in there to recover them. The administrators may have put the chains on the gates and they say, look, absolutely not. No one's coming in to recover the goods. We need to assess the situation and work out what we can distribute and recover where and when. But if you've got that right to do so, it gives you a much better claim to get those goods back. Alternatively, you may see a situation whereby the customer has actually sold those goods on to a third party, their own customer, received payments for those goods, but not paid you. If you've got a clause in your contract that states that any monies which they receive for those goods are held on trust for you, then again, if that party goes into financial difficulty, you can waive that contractual clause at the administrators to say, we've got a right over that money there and then. Again, it's not a hard and fast remedy, but it does give you a much better case in the event that the administrators take control of a company. So do make sure you look at those clauses very, very carefully and don't underestimate the power of a retention of title clause. The final question which I've been asked, and which is a relatively quick one, is the Intellectual Property Office affected by the lockdown? Can I still register intellectual property rights? The Intellectual Property Office deals with all applications to register trademarks, to register designs for your products as well. They are still operating. They are pretty heavily affected by the lockdown situation, and they are seeing a very small skeleton staff working from home, which means that we are experiencing delays. But if you do want to register any intellectual property, it's still possible to do so at this time. But just bear in mind that it's going to take a little while longer than we would normally expect. Okay, so that's it from the questions that I had on my list. Stephen, have you got any more?
I just had two more, John, but if anyone wants to ask any in the Q&A box on your screens, please do feel free, and we'll happily answer your questions. But just coming to the last two that I got in advance, someone was asking about force majeure in relation to ongoing construction contracts. So construction contracts, as anyone who's involved in that sector will know, there are a particular form of contract, and they're often in a JCT form or NEC form, and they're often amended as well. So you need to be mindful of what amendments have been made, but the standard position in relation to force majeure in JCT contracts is that it does contain a specific force majeure event, force majeure clause, and it is cited as a relevant event under the contract. The clause is 2.29.15. I made a quick search of it before this event. And in NEC3 and NEC4 contracts, again, at clause 60.119, there is a force majeure provision described in the guidelines there. And it does give rise to a compensation event. So given that COVID-19 is a pandemic, it's very likely that it's going to amount to force majeure in relation to JCT and NEC contracts. And it's therefore likely to afford contractors the options to seek extra time to complete works. I don't think that's likely to be disputed. The JCT provisions for loss and expense to be paid to the contractor in respect of certain relevant events, but force majeure isn't one of them. But again, depending on what amendments you've made, that might be different. But it might be possible to argue that some of the lockdown measures that the government has put in place, do amount to other relevant events under the contract, which do provide for loss and expense to be paid. So again, it's key just to have a look at what your contract says there. With NEC 3 and 4, on the whole, they're better, I would say, the standard position at least. It's more advantageous certainly to contractors as it carries the right for more time and money, and it's likely that COVID-19, as I say, will be a compensation event. The NEC 3 and 4 contracts do require, however, claims for compensation events to be made in fairly strict timeframes from first date of knowledge, so keep an eye on that. If you're operating under a JCT, on the other hand, on an ongoing project, you need to be looking at the specific contract in place and apply for extra time as soon as those delays start to occur. That's going to give you the best chance. And any other relevant events which might apply and help you. And as I say, the NEC 3 and 4 projects compensation event notification should be made within the time frames. Just get some advice on that if you're in that situation. So just moving on to the very last one I had in advance. This is on insurance, and it says, will insurance policies cover business disruption losses? It depends, I suppose. A business that suffers loss under a contract as a result of disruption arising from COVID-19 should obviously check any policies that they've got to see if there's cover in place. It is fairly common with insurance policies that strict conditions for notification of claims exist, and by now you should have notified your insurers if you think you have indemnity under your contract. Again, it depends factually on when you've been affected and how you've been affected. So check your policies to see what cover you've got and check the notification provisions. It's absolutely key that. Subject to the wording of any specific business interruption policies that you have, there is obviously a potential for an indemnity against things like trading losses as a result of the coronavirus. And so you just need to check that policy to see whether you might benefit. A lot of insurance companies are probably gearing up for a bit of a battle at the moment, but that's because a lot of people are bringing claims. So check your policy, see what it says. You do obviously need to carefully consider any exclusions within the policy and check whether or not the cause of the loss is the insured event. Insurance policies are notoriously technical, so make sure that it's either insured or the excluded event. It can be drafted in different ways. I've seen it like that. For example, you might have an employer or a business who chooses to close down their business to protect its employees, but there was no particular regulatory requirement for them to do so. So you can see in that situation, there's likely to be a dispute as to whether or not the cause in that particular instance is either the choice of the insured or the pandemic. So I think, coming back to the question, yes, in principle, some policies will cover this. Some policies will specifically exclude it. It's something for you to check and get advice on. And I suppose something to bear in mind moving forward as well when you come to renewals. You need to be asking whether or not this is something which can be included. So hopefully that answers that question. I didn't have any extra ones beyond that, John. I don't think there's any in the queue.
No, I don't think any more have been raised, but we'll just give people a moment or two if they do want to do that. I believe you can also ask questions anonymously. But if you'd rather not ask in the forum of this Q&A session, then please do just drop us an email. I'm sure you all have our details, and if not, then Gabrielle from our marketing team will be able to send those across. So it doesn't seem that any more are coming through. So thank you everyone for joining us today. And we will let you know if we have any more questions that are being asked commonly enough, and we can roll another one of these out. So thank you very much.